Hello everyone, Derek Johnson with Tatango.com. Today is another TCPA case review with Joe Bowser from Innovista Law, home of the TCPA Defense Force. How you doing, Joe?
I'm doing well, Derek. How are you?
Good, man. Can't complain. So we have a new case here, which is, and I'm most likely am butchering this person's name, Reichman versus, I know how to say this one, Poshmark. And Poshmark is an app, a mobile app. So I'm going to read through kind of what my notes are here, and then you can fill me in, and then we can discuss, why is this important for text message marketers. So Poshmark is an app, and I'm pretty sure Poshmark is an app like women, I think, primarily put their clothes into the app, and then they can like trade and sell it and stuff like that. Is that what you got from this app? I don't know if you use this app.
I do not use it.
Okay.
I understand that you can build a wardrobe or a closet or whatever.
Okay.
Obviously, it's virtual, and whether you trade or not, I don't know.
That's all we know about. Yeah, maybe we should download the app before we do these. Okay, so this app, yeah, or bring somebody on that's knowledgeable about the actual app. But the nice thing is, it doesn't matter what kind of app it is, because the TCPA really doesn't care about what the app actually does. It's more about what the application does, in terms of the phone calls or the text messages. So this can apply to really any app, whether it picks you up, like an Uber, or organizes your closet.
Right.
So
we can make one for our woodworking tools or whatever we have them want to sell. Right?
Yeah, exactly. So this app allows users to invite their contacts to join Poshmark by text message or various social media platforms. So people upload their clothing, they build a closet, and then they invite their contacts on their mobile phone, so their friends, to join them, essentially. Create their own account and, trade and buy things, make comments, like, all those kind of social media type actions. So this person, she is a and I think this is a woman here. She is a Poshmark user with over 14,000 members who follow her closet. So it sounds like she's almost like a power user. I would hope she's a power user of Poshmark. And she used a find people tool, I guess, within the Poshmark app. And it's essentially what I just explained: find people to invite them to follow this person on Poshmark. And maybe that's why she has so many, followers, 14,000, because maybe she's using this tool. So it sounds like an effective tool, to get followers. So Poshmark app gave her two choices. She could individually select contacts to receive an invitation to join the app. So that's kind of a slow process. You got to click each one, and then, send it. Or she could invite all. And they have that in quotation marks. I'm guessing it was a button or something like that. Invite all of her contacts. So this would actually invite all of the contacts in her phone. So everybody,
whether she has their phone number, their social media accounts, etc.
Okay, perfect. So she chose the latter, which would be the invite all option, because it seems like the easiest, which caused an invitation to be sent to the plaintiff. So the plaintiff is this Reichman person. So I don't know if Reichman is a female or male.
The name's Christopher.
Okay, so most likely a male, but the person that actually sent the text message, I guess the person with the Poshmark account, was a female. And I think I messed that up earlier. So she sent this out. Let's hypothetically, this Christopher person, he received a text message, and the text message read, view and buy the wares now being sold through Poshmark, and essentially linked to join Poshmark, and then link to most likely her app or her profile within the app. So
that's right.
He received it, and he's like, what the heck is this? Obviously, because he didn't opt in for these messages, and maybe he even met this person once, and now he's being essentially kind of spammed with a message asking to join Poshmark. And I don't know. He
probably wasn't expecting this.
Yeah, exactly. And I don't know if, and this would be interesting, I don't know if in the Poshmark text message, was her name in there? Like I guess the person that actually triggered the message?
Mm-hmm.
Because that would be super confusing for me if I received a message just from Poshmark. I'd be like, wow, this is definitely spam. Maybe a little less spammy from a conceptual standpoint if it had like, hey, this is Derek, I have a Poshmark account, but still kind of spammy.
Right. So I think to figure the answer to that question out, the way the case describes it, it says that he's given a link to her closet.
Okay.
So if she has a pseudonym and it's not Miss Tolentino, which apparently is her name, the woman who sent out the invitation.
Okay.
If it doesn't have her name on it, he may not know if she has some alias that it's really her.
Yeah. So really confusing kind of consumer experience, obviously, from the person receiving the message, because they're like, number one, I don't know what Poshmark is. Number two, I might not know this person. I'm receiving a text message out of the blue with a link. There's things called phishing attacks where they're fake links to, people pretending to be your bank. So this just seems very kind of spammy or scammy. So what happened? So this person was obviously upset. And was he upset at Poshmark, or was he upset at this woman that used Poshmark's app to message him?
Well, he's clearly upset at Poshmark because he sued them.
Okay.
Right. It's not clear whether he, filed a claim against Mrs. Tolentino. It's pretty clear that he didn't. And he only got 2 messages.
Okay.
And apparently Miss Tolentino sent him essentially the same message twice for whatever reason.
Okay.
So he got 2 messages and then filed this class action lawsuit suing Poshmark for being the sender of these messages.
Okay, and I know we've reviewed this on previous TCPAs, but case reviews. But explain, what is a class action, and why do people do that instead of just filing a lawsuit against somebody or a business?
So if you file a lawsuit in your individual capacity, the only thing that you can get out of that case is whatever your damages might be, right? So if you hit me in your car, I can sue you for hitting me, but it's just my injuries that I can recover for. If you use the class action vehicle, you can say that there are a number of people that have similarly situated circumstances, and it would be inefficient for the courts to resolve these on a case-by-case basis. So why don't we lump everyone together? And what it really is a vehicle for the plaintiff's attorneys to try to get much larger settlements and a substantially higher amount of attorney's fees through that kind of recovery.
And he, as a consumer, if it was found that this was a violation of the TCPA, what can he actually sue for? It's $500 and $1,500 per text message?
So individually, his maximum recovery for this case, where he got 2 messages, would be $3,000, or his actual damages, if they're higher, but of course they wouldn't be because it was just 2 messages. So unless Verizon or AT&T or whomever he was using for his carrier was charging him more than $1,500 per message, which I'm sure it wasn't the case, he'd just go for the statutory damages of $3,000, and that would require them to prove that it was an intentional act that violated the TCPA.
So, and that's why you do kind of the class action, because an attorney is going to look at that and go, winning $3,000 most likely won't even cover the attorney fees, for all the work that these things take. So let's get thousands or hundreds of thousands of people that feel like they've been wronged. Now we're talking 100,000 times 1,500 or maybe 3,000. Now we're talking some big money. Right.
Like last year in 2017, there were about 1,000 TCPA class actions that were filed across the country. So this is definitely the vehicle that the plaintiff's attorneys will use to maximize leverage against the brand to try to get that big settlement.
Okay.
The individual plaintiff whose name is on the case, they'll get often a small additional payment for going through the trouble of being the class representative. It's anywhere from maybe $2,000 to $3,000 up to $15,000 for the very complex cases.
Okay.
So they might get a little extra bonus, as it were, for being deposed when none of the other class members had to be deposed. They had to be available for court hearings and things like that sometimes.
Okay.
So they may get a little extra bone, as it were, for being the named plaintiff. But the real benefit is for the plaintiff's attorneys, who can generate up 7 figures in fees often.
Wow. Okay. And I was actually talking to some friends last weekend, and they were very surprised that you could sue a brand anywhere from $500 to $1,500 per text message, where sometimes even if you get hit by a bicycle or a car, your damages aren't even $1,500. So where does that number come from in terms of, I guess, the damage. Like, if I get one text message, I feel personally that didn't damage me $1,500 or $3,000 if I get two. Do you have to, with TCPA cases, do you have to prove like that was hugely damaging to me, like that woke me up at night and at my sleeping rate is $1,500 an hour?
Not at all. Not at all. The numbers for the damages come from Congress in the law itself. So the TCPA was passed in 1991, and that amount of damages was meant to incentivize people to bring small claims court cases against whomever was violating the Telephone Consumer Protection Act. So I don't think Congress ever envisioned that it would become this, poster child of class action lawsuits that it's become. And TCPA cases are now the second most common type of civil case filed in federal court. So what Congress envisioned in 1991, before there were even SMS that were exchanged commercially, is a far cry from where we are today. So it was really just meant to give people an incentive to discourage people from, bothering people at the dinner table and the kinds of auto dialing that were bothering people in the late 80s and early 90s.
So you could, and I've been to small claims court before, you can essentially represent yourself. It's very simple. You're essentially kind of, I reference it like me and my sister arguing with my parents, like being the deciding factor. You don't have like, witness, like a huge amount of witnesses and things like that. So it essentially allowed them to just go in there and, it would be worth, I guess, some people's time to spend an hour or two to fight something, where if it was only $1 that they could recover, no individual person would ever waste their time.
Correct.
Okay.
Correct. They needed to give enough of an incentive for people to go into court and at least, disincent the bad guys, as it were, from continuing that practice. Because back then, the dialers weren't terribly sophisticated. They were literally just dialing in sequence, right? Whatever the 10-digit number was, plus one again, and the dialer would just go in that fashion, making whatever solicitation calls they were making.
So it almost gives the brands and the dialers a little kind of fear, because if it was only $1, they know that the consumer would never waste their time to go to small claims court. So by putting it so high, they go, well, we might want to follow the rules because there's a chance somebody's going to take this, to small claims court. But I think what has happened lately is plaintiff attorneys have looked at it and go, well, if we combine all these people, they don't have to go to small claims court. We can sue for, I've heard 300 million, billions of dollars. Like, these are huge lawsuits.
Right. Like the Dish Network case that's in the news a lot, the exposure there was something like $8 billion for the amount of.
So this is not small claims court type stuff anymore. This is serious money.
This is large claims court.
Okay. So with this Poshmark, what happened? The case has been resolved, correct?
Correct. It's actually been dismissed.
Okay.
There was an appeal filed after this opinion came out, and soon thereafter, the parties filed a stipulation of dismissal with the Ninth Circuit Court of Appeals. So my assumption is the case settled. Okay.
And explain to me what happens when a case settles compared to like actually gets settled in court.
Well, if the class is certified, then the judge needs to approve the terms of the class settlement. But in this case, the plaintiff either gave up on the case and just agreed to dismiss it, or perhaps Poshmark paid him a few bucks to just put the case away. Poshmark got a good result in this case, so they were perhaps content to maybe throw him a few bucks just to keep this good ruling in its back pocket, probably discourage future plaintiffs from suing them again, and move on with life.
So was there actually a ruling for this case, or did
there was,
okay.
But the ruling was at the trial court level.
Okay.
So the Southern District of California, I think it was in San Diego, issued the decision on summary judgment. Poshmark had lost an earlier motion to dismiss, which is the kind of motion you file early in a case that basically takes everything that the plaintiff says in the complaint is true and tests the legal adequacy of those allegations in the complaint. Okay. They lost that one early in the case. And then after some discovery, which is when you kind of exchange documents, some folks get deposed, things like that, then they filed a motion for summary judgment, which asks the court to essentially say, the facts that matter aren't in dispute. Here's what happened. Everybody agrees on the essential timeline of events. So court, since the jury doesn't have to decide any disputed issues of fact, please tell us that I win as a matter of law in light of the fact that the facts really aren't in dispute. And that's the motion that they won, this motion for summary judgment.
Okay, so and then that essentially kind of ends the case.
Well, it would end the case, and then the plaintiff, Mr. Reichman, appealed that.
Oh, okay.
But then clearly the parties resolved it after the plaintiff filed the appeal.
And that kind of information about how it was resolved is kind of private?
Typically, yes.
Okay.
Yeah, you wouldn't see that in the docket unless something strange happened. But again, if a class had been certified, the judge has to approve that under the relevant
so the
rules.
class wasn't certified, right?
Correct.
Okay,
yeah.
so it didn't get that far yet.
Nope, because the trial court found that the individual plaintiff didn't even have a case.
Okay, so let's talk about that. How did Poshmark, because it seems like, this person got kind of a text message spam, a text message they did not want. They sued Poshmark. It kind of feels like a slam dunk case. Why was it thrown out of court?
Because the key issue in this case was who sent the message. So in app cases, in a lot of website cases, and in platform cases, like with the Tatango platform and other SMS platform providers, a key question is who sent the message, right? So in the TCPA, a key verb is to make the call or to initiate the call. So the court needs to figure out who is the initiator, who is the maker of the call, so that if you didn't do that, you're not liable. And the FCC has set out a test that really lays out the roadmap for figuring out whether the app, the website, the platform provider is the initiator, or whether it's the user of the app or the website or whatever technology is being used to facilitate the delivery of the call or message. So that was the key issue in the case. Did Poshmark send the message, or did Mrs. Tolentino send the message?
So the court case was thrown out because this person sued Poshmark, and Poshmark said, no, you shouldn't be suing us. We weren't responsible for this. Essentially the user, this woman with the closet on Poshmark, it was her that sent the message, not us.
Correct. Right.
Okay.
So there was a fight. Like if I'm driving a Ford and you sue Ford, obviously Ford would say, "Hey, I just sold the car. I didn't drive it. I didn't know there was a stop sign. I just sold the car, and I'm not liable for that." So that was essentially Poshmark's argument. I wasn't steering the show. I wasn't driving the show.
Because she had two options. She had the invite all option, and she had the invite individual. So she was doing it herself. Like she was clicking through, making all the decisions herself. This wasn't Poshmark just scraping all her contacts without her knowledge and sending it to them. She made this decision.
Right. And that's really what the court relied on. There are two FCC cases that kind of set the two relevant goalposts. There's the Glide case on the one hand, where Glide basically raided the user's contact list and without their permission or consent sent messages saying, "Hey, Johnny's on the Glide app. You should download the Glide app and join them in the app experience." The FCC found that Glide sent those messages because the user had no involvement, right? Glide decided whether to send the message, when to send the message, and to whom to send the message. So, and the FCC really didn't have any difficulty deciding that Glide, you're the sender of that message. But then in another case, the FCC had a Text Me app where the user, like in Poshmark, where Poshmark clearly, or pretty clearly looked at that case and said, let's architect the user experience here to mimic what the FCC was looking at in the Text Me case, so that the user decides who gets the message, whether they get a message at all, and then which particular recipients get the message. So that's what the court was really looking for here, was the FCC's guidance about who is the maker or the initiator of the call or text.
And it really doesn't matter, because I've heard a lot of people say, well, if it's if I'm clicking on each person and sending the message compared to sending it in mass, that wasn't this case. This was essentially who was responsible for whatever option she selected.
Yeah, you mentioned before that that the user had a choice about whether they picked some contacts or just sent it to everybody. I don't think that would have mattered in this case. If she just picked him and 3 other friends, he probably still would have sued because he doesn't care if other people got it.
Yeah.
That might have hurt his class allegations. But he probably still would have sued because he would have said, Poshmark, you sent that message because you essentially put the gun in her hand, as it were.
Yeah. So, and let's just play devil's advocate because I want to take this, as far as we can and learn from this. Essentially, after kind of what we've seen from Glide and Text Me and those kind of cases, he should have brought the case against the woman that was using Poshmark. Like, that's the appropriate person that is responsible for this, right?
Right. Mm-hmm.
Okay. So because she used...
But you don't see your friends, right?
Yeah, exactly. Well, it depends how good a friend you are.
You're not gonna get the holiday card.
Yeah, no, exactly. Well, and you never know. I'm guessing this guy wasn't that good of a friend. So I guess because she used the auto dialing function, which is kind of the mass messaging, where she just said invite them all and then send a mass message to them, compared to individually selecting a contact and sending a message, a contact selecting a message. Would there be any difference between the two? Like if that were brought to a court, would there be a difference? Would the judge look at it and go, well, yes, it's an auto dialer because she sent it en masse, or no, it's not because she sent it individually?
I don't think the quantity of messages being pushed out is really what matters here. The question was just who's making the call. Now, if the question is she using an auto dialer when she's the defendant, that's a different question.
Yeah, let's say she is the defendant. Like, if he should have sued her, obviously, because she was responsible. I think we're getting to the point now in kind of the history of the TCPA that we know that the software providers, the app makers, they're most likely not responsible if they're following kind of this playbook, where, it's the user's choice to text message people. So if they did sue the appropriate person, the person that actually triggered these messages, would there be a case that one option, the invite individual friends, would not be an auto dialer, or is just everything considered an auto dialer now?
Well, that question became very unsettled, of course, in March of 2018 when the D.C. Circuit decided the ACA appeal, which was the appellate challenge of the FCC's 2015 ruling, which in relevant part defined an automatic telephone dialing system as anything that had the future capacity or potential capacity to act as an auto dialer. That obviously got thrown out by the D.C. Circuit, and courts now are struggling to deal with how to treat the auto dialer question in that vacuum now that we don't have any controlling FCC guidance. This case was filed in California, as we mentioned earlier, and the Ninth Circuit has a case in front of it now called Marks versus Crunch, where they requested supplemental briefing about just that question. What are the courts to do now in light of this vacuum that's been left in the wake of the D.C. Circuit's opinion kicking out the FCC's ATDS definition from 2015?
So it's still kind of up in the air. There's not a definite, like, this would be auto dialer, this wouldn't be.
Correct. I think, the argument we're taking now is you continue to look, as many courts had, even in the face of that kind of impossible FCC definition of the level of human intervention in any given call. Because the thing that bothered the DC Circuit about the FCC's interpretation was that we were all walking around with an auto dialer in our pocket.
Because
that just can't be.
Right? Because the phone could, even though most people don't use it as an auto dialer, the ruling or the law said if it could, like, that's almost like saying if the car could go 200 miles an hour, you get a speeding ticket. Right.
And that's what was bothering the judges in the DC Circuit. We can all group text 5 of our friends. Am I subject to $500 per text liability just because I can do that with my iPhone? The judges were very skeptical that that's what Congress had in mind in 1991.
Okay. Because back in 1991, there wasn't smartphones. It was a different landscape.
Right. The only people who could auto dialer were using, sophisticated technology, and no one had it in their pocket.
Okay. Interesting. So from let's just say that, app manufacturers and marketers are looking at, this video right now. What can they learn from this, and what should they not be doing?
Well, I think this case illustrates what is now a pretty clear line between brands and users on the one hand and the technology providers that facilitate the delivery of messages. So as the lines blend and the brand starts helping with the marketing campaign, both the brand and the platform provider can be liable under the TCPA. But if one party is taking ownership of who gets messages, when they get the messages, and whether they get the messages at all, the liability pretty clearly lies now with whoever makes those decisions. If it's the brand, right? Like there are brands that say, I'm going to send out coupons for my partners. Well, if they're making those decisions about who gets the messages and when they get the messages, how often they get the messages, so on and so forth, well, then the platform provider is essentially acting like a lead generator, a marketing agency, what have you. And I think it's pretty obvious and clear that the courts will treat them like the sender because they're making all of the key decisions about when and who gets the messages.
Okay, so more, I guess, advising towards making sure the user is the one making all the decisions rather than what that other company did where it was the company made all the decisions for the user.
Yeah, I just think it's important that everybody understands the lanes that anybody's going to drive in and the consequences of being in that lane. There's nothing wrong in my mind in the abstract about blending the lines. You just have to know that you both might be on the other side of the V in a lawsuit, which is fine. If you both want to take ownership of the TCPA exposure, there's nothing wrong with that. You just both now have an incentive to make sure that you're compliant. Okay. Where if only one party is making the decisions and taking responsibility for those key decisions, then that is the company or the entity that really needs to be taking exclusive ownership of the compliance questions. Okay.
And just to give a little kind of background, I guess, for the non-attorneys that are watching this, let's say, Poshmark, and I know you're just you don't know exactly how much they spent or how long this took. How much does it cost and how much time does it take to even just throw out a case at where this case was thrown out? Like, it seems like this is kind of that exposure where you're kind of playing this gray kind of field where you're trying new things. It exposes you to stuff, and even though you might be in the right, you still have to defend yourself, which can be very costly.
Yeah, defending particularly class action litigation, and depending how the court handles the discovery issues, which can be complex and onerous, it's not uncommon for the defense of these cases to hit six figures. This particular case was filed in 2016. It wasn't resolved until 2018. Wow. Okay. So, it's definitely conceivable that it was distracting to the business people, to the engineers who, may have had to be deposed and prepared to be deposed to explain how the system and the platform works. You've got to go through the document discovery to be able to dig up the information to show, for example, that a particular user consented to receive messages. So when we do the litigation defense work, we understand and are sensitive to the fact that it can be disruptive to the business people. So you want to get the attorneys who are cognizant of and appreciative of the level of demand that it can put on the business people and the engineers, and only ask those targeted questions that matter to the outcome of the case, so that you're not distracting the business people needlessly and bogging them down in a whole bunch of Q&A or discovery when it's not going to be relevant, and where to choose your battles with the plaintiff's attorney, who predictably is going to ask for everything under the sun, because the more burdensome they can make discovery, the more likely they can extract a favorable settlement.
Okay, interesting. And I guess it really comes down to, for some of these apps, it's really the trade-offs between kind of growth hacking is, I guess, what our industry calls it, doing things that, and I think we have another case coming up, there's another growth hacking kind of way that they used it in the car case we're going to discuss later, versus spending all this time and money potentially having to defend yourself, even if you're in the right. It's still kind of in this, like, people are upset with you category. So I think people have to, first, before they do this kind of stuff, I would always recommend they go to a TCPA attorney like yourself, and they discuss, what the exposure is, and then is the growth hacking technique that they're proposing, is that worth the exposure? And I'm guessing in this case, because this person has 14,000 people that follow her closet, I'm guessing this worked pretty well and is a good growth hacking strategy. So that might be worth spending millions of dollars defending yourself. So do you recommend that people, before they try these growth hacking strategies, to come to you, and then you would walk them through, their exposure? You would tell them, like, okay, if you do get sued, even if you're in the right, it's going to cost this much. Like, is that a normal conversation you have, or it should be a conversation that people are having?
It's absolutely a normal conversation we have, and it's the best conversation we have, because it's the old ounce of prevention rule, right? It is dramatically cheaper to get it right on the front end and then have a clean case where you defend your business model on the back end. And then once you have that win from court, a lot of times the plaintiff's attorneys will go find lower hanging fruit and won't bother you again, right? So you want to architect it correctly on the front end, and then it's America. You can't stop anybody from suing you. But then once you have that win, a lot of times you're, a lot more insulated than you otherwise would have been. And the worst case scenario is you did it wrong, and now you have potentially,
billions.
Bet the company litigation because of the exposure associated with the statutory damages. Do
in these cases, do the companies that, like Poshmark, do they ever try to get court fees and attorney fees back from the person that, I guess, wrongly sued them? Or these kind of things, usually if it's just a person, they just kind of say, thankfully it's not $1 billion lawsuit, and we just walk away?
Well, unless you have a contract or a statute that allows parties to shift attorney's fees, the so-called American rule prevents courts from awarding fees to the prevailing party. So unless you have a contract that allows it, and in this case, there probably isn't a contract between someone like Poshmark and the recipient of Mrs. Tolentino's messages, because they don't have any relationship, right? Mrs. Tolentino chose to send that message that happened to have a link to the app. So absent that contract or a statute, and I can assure you the TCPA is not one of those statutes, you kind of have to take your lumps and eat those fees. So that is the cost of doing business. Now, what we certainly work with clients on is getting insurance coverage for this kind of exposure. It's because it
is different than just like insuring your building or a slip and fall. It usually is kind of its own insurance policy.
It is a niche product typically. And a lot of times, so it's a third party product, and many so-called commercial general liability or CGL policies don't cover TCPA exposure. A lot of people think if they just have advertising coverage, they're fine, but there are a number of rulings out there that either restrict the scope of that coverage, or in some cases have found that because the statutory damages are treated like a penalty, some states' laws prohibit you, absent other circumstances like an explicit rider to the policy, from insuring for penalties. Because it's kind of meant to not shift the sting of a penalty.
Interesting.
So some state laws provide that you really can't insure for like those kinds of penalties.
And people
that are meant to be punitive.
Like brands will come to your law firm to have you guys review their insurance policy and then help them figure out either if they have it covered, or help them actually like send them in the right direction and make sure it is covered, right? Like this is something maybe you don't even want to go to your insurance company. You want help going to your insurance company to explain what you're looking for.
Correct. Because in most cases, the reflex of the carriers is to just have an exclusion for TCPA coverage, or just try to throw a fastball knowing that it's most likely not going to be covered under a standard commercial policy. So we work with them, put them in touch with brokers who we know have been able to place these policies in the past and know the carriers that will offer this kind of coverage. And then the other thing we do, because state law can be pretty nuanced in terms of indemnification clauses in their own contracts. So some states, for example, unless you say that you can get indemnity for certain kinds of claims, like strict liability claims, which TCPA claims often are treated as strict liability claims. The regular in-house counsel might think, oh, I've got an indemnification clause with the person who's using my service. I'm golden.
I don't need insurance. Yeah.
Well, you either need insurance.
No, I'm saying they might say, oh, I'm good. I have an indemnification clause. I don't need insurance. I'm good. You're saying that sometimes that
clause isn't worth the paper it's printed on for TCPA liability. So so there are definitely TCPA specific issues that whether it's contractual or insurance related, you want to definitely have someone who knows the ins and outs of the TCPA landscape to get good advice there, because it is state specific.
Okay. Wow. And I think this video shows that, I think we were even talking about this. Hopefully there's enough in this case to learn from. And as you can see, it just goes off into, different topics and things you need to worry about. This is why I think it's so important to, number one, focus on the TCPA. So if you are doing text message marketing or integrating text messaging into an app or, some kind of solution you're offering, is go to a third party like, Innovista Law, like you guys, a TCPA attorney, because there's so much stuff that you have to think about before even sending your first text message. And it's not as easy as, well, we had, this little disclosure here. It's never that easy. You have to look at insurance. You have to look at indemnification, what city or state you're in, how the workflow of the message, this is not easy stuff. You can't watch a YouTube video, unfortunately, and just figure it all out. Even though I love our YouTube videos, this is more just to educate, to get you kind of past the normal level up to here so that you can then talk to the people that are up here, like the TCPA attorneys.
Yeah, I mean, I try not to talk about this at cocktail parties. It does get fairly complicated. Yeah. But I appreciate you giving us an opportunity to talk about it. But yes, it is nuanced. It can get state specific. The federal courts are not in agreement in many material respects. So anything we talk about here is pretty high level, and you definitely want to talk to somebody who is trained in the arts, as it were, in this area of the law.
Now, speaking of high level, you guys have a great website, great blog, a ton of resources. Your blog is always up to date of new stuff that's coming out, cases, similar to kind of these videos. What's the website?
The website is tcpadefenseforce.com. tcpadefenseforce.com.
Okay, perfect. Okay, that was a great TCPA case review. That was Reichman versus Poshmark. Obviously thrown out because Poshmark was kind of determined to not be the sender. It was the actual person that was clicking the button to send the message, which also applies to software companies similar to Tatango. There's all kinds of different cases, and I think this is becoming more and more kind of standard that, it is always the responsibility of the person clicking send and knowing when to click send and typing out the message. It used to back in the day feel like kind of it was up in the air. It feels like most cases now are kind of have determined that, it's not usually the software provider if they're just providing software that allows the user to do all those things.
Right. I'd put a caveat on that. Obviously, the people behind the sender, right? So if you're paying someone to hit send, as it were, then obviously you can have vicarious liability for the folks behind you.
And that's a marketing agency. So,
correct.
There could be, it's not as easy as always just well, you're the sender, you're not the sender. There could be multiple senders, involved in this thing. Or, a brand can be paying a marketing agency, and then maybe it's the marketing agency's, liability because they're the one that are scheduling it, typing it, clicking send. So there's a bunch of things you can learn from this case and from previous cases. And really, again, I always recommend people go to a third party. Don't go to the software provider you're using for your TCPA advice. Go to a third party that knows TCPA law, because it's always changing. It's very complex. And, just make sure that you're covered before you start trying to growth hack and you start, launching an SMS campaign. It's always better to do it before than, have to contact you when you get that letter from one of these consumers.
Right.
Okay,
Don't
perfect.
underinvest in legal and regulatory. Exactly.
Exactly. Yeah, it's like insurance. You got to pay for it up front, and it'll definitely pay in the future, hopefully. So,
Right.
Again, that is Reichman versus Poshmark. My name is Derek Johnson with Tatango.com. This has been another TCPA case review with Joe Bowser from Innovista Law, home of the TCPA Defense Force. Thanks, everyone.
Thanks, everybody. Thanks for watching.
Thanks.